these hunting and fishing and trapping rights over all surrendered portions of land. So if one sees the treaties, and they had their benefits, they had annuities, a few £1,000s, I believe. I think it was £4,000 in total, and annuities. I'm not sure if it was £1,000 per year or £4,000. But in any event, not significant sums of money now, a little more significant then. But the main point was that basically what they were doing then, they were allowed to continue. They were allowed to use these lands to hunt, fish, and trap. And it was interesting to note that the terms used there were lands not actually used or required for settlement. Well, of course, in that vast country still in 1850, that meant that very few of the lands would actually be taken for settlement. So these treaties became the model for the post-Confederation treaties. The next big impetus of treaty signing was between approximately 1871 and 1877. And there were 7 numbered treaties which opened up the Canadian West. Now, the 1850 treaties can be argued were basically in royal proclamation in Indian territory. And therefore, this was just giving, following the procedure which had been essentially laid down by law, that they were supposed to, before occupying a particular land, before settling it, deal with the Indians, obtain a surrender of it. Between 1871 and 1877, one was dealing mostly with the Hudson's Bay Company territory. This fact was held to be without significance, if I can put it that way, by the Court of Appeal of Quebec in the recent James Bay judgment. So I have to be very careful in my comments on that. But between 1871 and 1877, most of the prairie provinces became the subject of the treaties number 1 to 7. They followed essentially the same format. That is that in return for their interests and rights in land, Indians were given reserves, mainly on the basis of 1 square mile per family of 5 persons. They were given certain additional benefits. The money was still small. Annuities were in the dollars, a few dollars for the annuities, but they were allowed to continue to hunt and fish and trap on unoccupied Crown lands. And that was an expression which caused a great deal of difficulty later on. But it was the same basic format. They were allowed to continue to hunt and fish and trap in the surrendered areas. However, out west it was a little more difficult because most of the surrendered areas became used for farming. It's also interesting to note that when most of those treaties were signed, those lands were under federal jurisdiction. And at the same time, most of the, well, there were Dominion Lands Acts which contained provisions saying that in essence, the provisions of the Act dealing with agricultural leasing and various land concessions, that most of the provisions of the Act did not apply to lands where the Indian title to those lands had not been previously extinguished, which seems to be a formal recognition of some kind of an Indian title in the Hudson's Bay Company land. But of course it's arguable the other way. Between approximately 1877 and 1921, there were 3 more treaties, 9, 10, and 11. And of course, Treaties 8 and 11 cover a large part of the Northwest Territories, and Treaties 8, part of Treaty 8 actually touches a bit of British Columbia as well. And they were the subject of the decision in the recent judgment rendered by Justice Morrow in the case called Paulette in the Northwest Territories, dealing with the Northwest Territories Indians. So that by the time 1921 came along, you had various adhesions to treaties too. Almost all of the prairie provinces, almost all of Ontario, and perhaps close to half of the Northwest Territories had been the subject of treaties with the Indian people who had lived in those lands. Except for a small portion of British Columbia, most of British Columbia was not the object of any treaty. The Yukon, in the Yukon, except for a tiny portion of the Yukon, there was no treaty with them, with the Indians of the Yukon. There was no treaty with the province of Quebec, with the exception of a very small adhesion to a treaty around the Abitibi area, which I won't get into. In the maritime provinces, there was no land cession treaty as such. Some of this can be explained by different historical development. Perhaps some of it can be explained by the push for settlement. Perhaps a large part of it can be explained by the fact that when the Royal Proclamation came along, there had already been substantial settlement in Quebec and in the maritime provinces. Perhaps some of it can be explained by the fact that really in the non-treaty areas such as the Yukon and part of the Northwest Territories and perhaps part of northern Quebec, there was no real need for this because the push of settlement had not come. The northern frontier had not been open. There are several reasons which one can give, but it's probably a combination of many of these reasons which resulted in no treaties being signed in those parts of Canada. Now, what are the treaties? From a legal point of view, they are basically contracts, just agreements, whereby one party gives up rights which it might have in land to another party who accepts those and in return does a certain number of things, gives a certain number of benefits. The courts have not interpreted treaties as being solemn compacts between sovereign nations. The courts have never recognized the Indian people of Canada as being sovereign people, as being sovereign nations. I know this is not what the Indian people feel as a whole, and I'm just telling you what is the law as interpreted by the courts of Canada, but the law is very, very clear. Indian people have not been regarded as sovereign. What is the nature of the treaties themselves? Can those treaties be broken? The answer is clearly that the treaties, in a sense, bind the Crown, but in another sense, when I use the word Crown, it's just government, but in a sense, do not. They are not a restriction on Parliament's authority on sovereignty. Parliament can, in effect, breach treaties. It can break treaties made with the Indian people, and it already has done so by legislation. The Migratory Birds Convention Act is a prime example, and in the case of Rex versus Sikia, decided in 1964, it was clearly mentioned by the Northwest Territories Court of Appeal that this was a breach of a treaty which had been made with the Indian people. So the treaties do not take precedence over Parliament's laws, over laws enacted by Parliament. Do they give rise, nevertheless, to some kind of an obligation against the government, not against Parliament, but against the government? I happen to think so, unless Parliament specifically removes, if it can, I'm not even sure Parliament can, but I think it can, unless Parliament specifically removes all recourses arising out of a breach of those treaties, one could then sue the government of Canada for the damages or for the harm valued in monetary terms which has been caused from breaking the treaties. But if one tries to put treaties up at the level of international treaties, And of course, even international treaties are broken by governments, and they are not considered to be the law of the land unless a parliament incorporates them into its own land. But these treaties are not immune or guarded or protected from future federal action, and that is because of the doctrine of sovereignty. But while they are there, while they last, they're an agreement, they're a compact between the Indian people and the government, and they have to be made with the government of Canada as at least one of the parties. And as long as they are not wiped away by legislation, they endure and they impose obligations on both of the parties. And this is considered, whatever has happened in the treaties, this is considered to be a once and for all surrender. It has been considered by the government of Canada anyway to be a once and for all surrender of all rights which other Indian people in Canada in those areas may have had in the land. So what happens in the non-treaty areas? This, I'm sure, will be discussed to a greater extent next week, but it is highly arguable in many areas that these rights, the same rights which were the subject of the treaties, were not extinguished. That these rights still exist. Rights can, of course, be taken away or extinguished by Parliament other than by treaty. You know, they can be voluntarily surrendered in a treaty, or they can be simply taken away, eradicated, wiped out by means of legislation, parliamentary legislation, or even by what's called executive act under certain circumstances, by an exercise of sovereignty which is not necessarily found in legislation. So that one cannot say that these rights, according to Canadian law, will exist for as long as the Indian people want them to exist. They can be taken away. They are subject to the overriding jurisdiction of Parliament, so that one has to be very mindful of this when one is looking at the entire question of Indian rights. Secondly, there are many arguments in many areas of Canada, in the non-treaty areas, for saying that some of these rights, if they existed, no longer existed, or in any event were subject to all kinds of restrictions and have since become extinct, or were never recognized, for instance, by French kings, or may have subsisted for a particular time, but because of certain events, because of certain land grants, they are no longer, their continued existence is no longer consistent with the theory of absolute sovereignty or absolute dominion over lands, which the Crown enjoys, and that therefore they were wiped out, and that at best there's some kind of a claim for damages which might still remain, and even that may not remain. Those are arguments against. You can make some pretty strong arguments for saying that these rights exist. And the basic argument, as I said earlier in the talk, is that this title that we were talking about at the very beginning, this factual occupation of land, gave rise to, in British law, a title, a right to continue to enjoy the land, which was recognized by British law, and that unless you had some positive act, either yielding it up voluntarily by the Indians, or a positive extinction of that act by either positive legislation or by a particular concrete executive act, that unless those things happen, then these rights continue. Even though it may seem to be an anomaly in this context, in this day and age, they must, it can still be argued that they exist and that they must still be dealt with. Now, in certain areas, you have the aid as well of various statutes, of various laws which seem to recognize the Indian right from time to time, has continued. We argued some of these in the James Bay case. In other areas, you don't have those same buttresses of your rights. You don't have the same force of argument, but differing in different areas, there are different arguments which can be used. Unfortunately, and I think Max will get into this a little next week, unfortunately in Quebec, the question is still undecided. One had the judgment of Judge Malouf, which recognized in a prima facie way, that is, in a preliminary way, at first glance, he didn't decide upon the merits. He didn't have to decide once for all, did they have the rights or didn't they have the rights. He had to decide, did it seem that they have the rights? He said it seemed that they had these rights in northern Quebec, and that Indians of Quebec in general had these rights. That flows from his judgment. The Court of Appeal was most categorical, far more categorical than Judge Malouf, and said that last week in its judgment, reversing Judge Malouf, that it seems very, very doubtful that the Indian people of the North had any rights. They had a little more problem with the 1912 Quebec Boundaries Extension Act, which mentions rights. And they said, well, for that act, maybe there are some rights, but it's just a right to damages once the project has gone through. And they said for the Inuit, they don't have any rights because there was never any treaty with the Inuit. I can't get into that too much more at this point, at least. But the main question now is what will happen in not only the non-treaty areas, but in the treaty areas. You've all heard about the famous case, the case which went to the Supreme Court of Canada, which started from British Columbia. In that case, a group of Nisga'a, Indians from the West Coast, asserted that they had Aboriginal rights or Aboriginal title, or the right to occupy this land. Those terms are all used interchangeably, as their forefathers had done for centuries, and that this right hadn't been taken away. The Supreme Court of British Columbia, which is like our Superior Court, said no, they don't have those rights. If they ever existed, if there ever was such a thing as Aboriginal rights, they've been extinguished. The Court of Appeal agreed with the finding of the British Columbia Supreme Court, and the Court of Appeal of British Columbia basically that Aboriginal rights do not exist unless they have been recognized in some way, either by legislation or by executive act or by some kind of a treaty reservation. The case went up to the Supreme Court of Canada, and it was heard by 7 judges. One of the judges decided on a procedural ground purely, saying that there had to be a previous procedure which was issued in order to be able to sue, the Crown. And it said this hadn't been done in this case, so he decided against the Indians. 3 judges decided for the Indians, and 3 judges decided against the Indians. In their opinion, it was one decision of the Supreme Court, but in their opinion, they would have decided in favor of the Indians, and 3 would have decided against. The result was 4-3 against the Indian people. But everybody recognized, first of all, since it was a 9-man court, since there are 9 judges in the Supreme Court, the 2 other judges could have made the difference. Secondly, it was recognized right away that one had decided on a procedural ground and had left the substantive issue unresolved insofar as he was concerned. And so 3 held that yes, an Aboriginal right exists, yes, it's subject to exclusive federal jurisdiction, it can be taken away at any time, but it has not been taken away in the case of the Nisga's, and I think the same sort of reasoning could be applied to large parts of Canada where there have not been any treaties. 3 judges of the Supreme Court, I'm oversimplifying it, but said that it is very doubtful that any such thing as an Aboriginal right existed because it was inconsistent with the assumption of sovereignty, with the taking over of full and complete dominion of the lands by the British Crown, but that in any event, even if it did exist, even if such a thing as Aboriginal rights did exist, that the Aboriginal rights in the case of the Nisga'a had been taken away prior to Confederation by a series of statutes, by a series of laws which granted lands in British Columbia and really ignored, for all practical purposes, the Indian interest. They also said in the Nisga'a case that 3 of the judges said that the Royal Proclamation did not apply as far west as British Columbia. 3 others said it may have applied. It probably did apply to British Columbia. The 7th one didn't pronounce upon the subject. In any event, all of them seem to agree that the Royal Proclamation as such, the specific provisions, did not apply to Hudson's Bay Company territory, lands, and we haven't argued that it does. That Indian territory, that Hudson's Bay Company territory lands, or Rupert's Land, was not within the Indian territory. We certainly haven't argued that, and that's fairly clear from a judgment of the Supreme Court in the Sigiaria case. But in any event, the Supreme Court left the question very much open. However, there are tremendous hurdles in going the judicial route, as was pointed out by the speaker right at the very beginning. I believe it's Mr. Dakari. There are tremendous hurdles in the way of going a legal route. One has to be extremely careful. It is quite conceivable that when the next case comes, and I assume there will be another case coming up before the Supreme Court of Canada, and it may turn out to be the James Bay case, when that next case comes, the Supreme Court may definitively decide upon that question one way or the other. But obviously, if it decides against the Indian people, then they're left with not very much. If it decides for the Indian people, then Parliament still has the weapon of being able to set up a claims procedure and extinguishing those rights by legislation. And of course, that was one of the elements in James Bay that was always a potential weapon of the federal Parliament, that federal Parliament could pass a law extinguishing any Indian right to people that the Indian people of James Bay had, particularly the Inuit. So that the question is very much open for decision. And in the meantime, the government of Canada, which in effect refused to recognize such a thing as Aboriginal rights up until approximately 1973, after the preliminary decisions had been made in the James Bay case, after the Calder case in particular came out in the Supreme Court of Canada on a decision, and after the proceedings had been started up north in the Northwest Territories case, came out with a new policy statement in effect, they didn't want to call it that, but in effect recognizing such a thing as Aboriginal rights for the purpose of dealing with those Aboriginal rights, for the purpose of dealing with those claims. And they were prepared to deal with them on the basis that the Royal Proclamation enunciated a general policy of Indian rights, and that in principle these should be settled on that basis, that there was some kind of a right or a title to continue to enjoy lands, and that it could be taken away, but if it hasn't been taken away in certain areas, then there should be this same process that was gone through with the treaty areas. The Northwest Territories case is a very interesting case from many aspects, but one of the aspects is that they are dealing in that case with areas where 2 treaties were signed. In certain areas, certain parts of the Northwest Territories treaties were not signed, but in that case they're dealing with areas which were the subject of 2 different treaties, not the same area, but different areas in the Northwest Territories had 2 different treaties, 8 and 11. And it was argued in that case, they had to argue that first of all there was an Aboriginal right, and that secondly that this Aboriginal right had not been given up, as people generally supposed, by the treaties, because it was not the intention of the Indians who were the parties to that treaties to give up their rights in the land. It was simply their intention to, in effect, enter into a peace arrangement with the government, and in return they would be allowed to continue to use their land as they had before. And they understood this to mean that they would continue to have all of their rights, and that the government would have to go back to them if they wanted to use the land for specific development purposes. A lower court judge, a Supreme Court of the Northwest Territories, Judge Morrow, decided that prima facie, he only had to decide what seemed to be the case. Prima facie, these treaties seemed to be invalid in the sense that the Indian people did not understand them as giving up their rights in land. So he said that it was appropriate for the person in charge of the land's registry, the person called the registrar, to warn people, to file a caveat warning people of the potential interest of the Indian people in this land, and that anyone who would develop that land would develop it at the risk of being subject to that particular interest. And of course, when you're in the development area, it's like building any building downtown or anywhere in Montreal. You don't want to build on land which may not belong to the person from whom you bought it, because he could otherwise come along later on and force you to demolish your construction. So that this throws a damper into development up north. That case was going to be appealed, and I believe is in appeal, but there was an agreement to sit down and talk in the Northwest Territories about possible claims. And what the Northwest Territories Indians did have going for them, in addition to a number of factors, was the fact that under the treaty, 1 square mile per family of 5 was supposed to be set aside as reserves, but no land was ever actually set aside as reserves in the Northwest Territories. They couldn't come to agreements for one reason or another. The Indian people say it's not their fault. The federal government says it is their fault. And in any event, they couldn't come to an agreement as to the locations of those reserves. And right now, of course, even if the Indian people only had 1 square mile per family of 5, if they were allowed to choose those reserves on some oil fields, they may not be so badly off. So that causes a very concrete and practical problem. That issue is still very much up for grabs in the north. I suppose that you've heard of a commission having been established to sort out claims. He only has powers of recommendation, but he can be a very useful vehicle, I suppose, in certain circumstances. That's Commissioner Barber, who was rejected by the Indian people. His job, back when he was first appointed, because he was tied in this white paper and the white paper policy, his job is supposed to be to sort out claims and to make recommendations to the government on how to dispose of those claims. Well, he's handled a number of them so far and has used his offices for that purpose. But by and large, the Indian people seem to be considering very seriously putting their claims not through the courts, but through the negotiation process, which has now been set up by the federal government. They now have a claims division within the Department of Indian Affairs and Northern Development, and people with outstanding claims inland can submit their claims to this division, and they study it and they start to negotiate. And active negotiations are now taking place in the Yukon in regard to the claims of the Yukon people. They seem to have started somewhat in British Columbia, but I'm not too familiar with what's happening there. There have been contacts that I do know, but how much farther it's gone down the line, I'm not sure. And I believe there are contacts, there have been preliminary contacts at least, with the Indians of the Maritime Provinces. And they may, this is towards arriving at some kind of a modern treaty or settlement or agreement in respect of land rights. It's in effect transforming rights which they have in the land into different benefits and keeping greater rights over more restricted areas, but in return for other compensatory benefits. I think I should leave it at that. The treaty process, interestingly enough, continued as recently as, I think it is 1956, when there were adhesions, meaning somebody joining to treaties. I think it was in Saskatchewan in 1956, a particular band joined it. The Indians who have participated in the treaties, interestingly enough, there too, it has not been restricted to registered Indians registered under the Indian Act. And this, of course, this Aboriginal rights theory has nothing to do with rights under the Indian Act. These are land rights over large tracts of land, not restricted to the Indian Act. And therefore, the people who had these rights were Aborigines or Aboriginal people or Indian people within the meaning of the Constitution, within the meaning of the British North America Act, which is much wider than the definition given in the Indian Act. I won't get into the Lavelle case, you probably heard of that, but it's not the definition of Indians as contained in the Indian Act. It's not only those people who had the rights. So that out west in the treaties in particular, and in Ontario, parties to the treaties on the Indian side, not only registered Indians, but non-status Indians, because they were considered to have some interest in the land. And so what is very difficult and thorny problem is that the people who have Indian blood, who are either non-status or Métis, as they're called now, some of their ancestors may have been parties to the treaties, some of their ancestors may not have been, and this opens up the entire question as to whether all of the people who should have been parties to the treaties, assuming that they are valid, out west and in Ontario, were actually parties to the treaties. And another big question now which has come to the fore, which is being pressed vigorously by treaty areas, I think in certain areas anyway, not in all provinces, but in certain areas, is they're saying, like the Northwest Territories, there were misrepresentations made to the Indian people at the time of the signing of the treaties, and offhand there seem to be a lot of arguments in favor of that theory. You know, it's a very tight legal document written in English. Most of them didn't understand what they were signing. I'm sure the interpretation could not be too exact. Indian treaty areas asking the treaties be examined and be put into modern terms, into modern thinking, with modernized benefits, and that too will cause a fair amount of, I think, a fair amount of controversy. But on the other hand, is perhaps going to be the type of solution which the government of Canada is ultimately going to have to entertain to try and find some kind of an equitable solution which will resolve the Indian interest in land once and for all, if it can be resolved. And of course, what the government has said to a number of Indian representatives on quite a number of occasions, and what some of the Indian people themselves are saying, are things like, well, are your descendants 25 years from now, if we make a new arrangement with you, going to say that you were tricked or that you've been deceived, and that they won't want to reopen the whole thing again? So that's a practical problem. So I hope I've given you a perspective, an historical perspective of the treaties in a little over an hour. It's a highly complicated and complex subject. I think that, just in summary, if you start off with the fact that Indians were there at one particular time, occupying physical tracts of land, were, for all practical purposes, the owners of those defined tracts of land when the white men came. British law recognized that they at the very least could continue to enjoy those lands, and for the most part, recognized that this enjoyment could not be cut off without the consent of the Indian people or without a particular sovereign act, so that for the most part, as settlement needs developed and arose, they asked for this Indians' consent to use those lands in return for other benefits. This was the treaty process which started across Canada and covers mostly from Ontario to British Columbia and parts of the Northwest Territories. The same process has not taken place in Quebec and in the Maritimes and in British Columbia and the Yukon for particular reasons. That right now there is a need and an assertion, there's a need to enter into treaties with a large number of groups, assuming that Indian rights still survive, but many of the government people argue that there never was such a thing as an Aboriginal right and base themselves on court decisions, or that if there was an Aboriginal right, it has been extinguished, so that this is the counterbalance to the Indian claims. But it looks like the whole question of claims and the modernizing of the treaties and actual perhaps signing of modern treaties or contractual arrangements is going to become a very controversial subject in the coming years, and the process has already started. Thank you very much for your patience. If you want to take a few minutes, then I'll try and answer some of your questions. Okay?
As you indicated somewhere in your opening remarks, this James Bay settlement is very interesting from the historical point of view, and is a history-making thing as far as the rest of Canada is concerned. If, you know, somebody 2 years ago had been looking forward and had been predicting that such an agreement was going to be made in Canada, I would have said that Quebec would be the last place to be made. Now, what was the driving force behind this? Have you any idea? I mean, there was a lot of money behind it, eh? Obviously, for all those hearings.
One, I think that undoubtedly the single most important event was the judgment of Mr. Justice Malouf. I think that absolutely surprised the government. I don't think very many people gave the Crees and the Inuit any kind of a chance to win that injunction, and the possibility that ultimately the Supreme Court may, at least in part, uphold some form of Indian rights also is a factor, especially in the light of Judge Malouf's decision, which was quite a thorough piece of work. Also the fact that we lost only 3-2 in the Supreme Court on the question of suspension. You recall that the judgment of Judge Malouf was suspended 1 week after it was rendered, the effects by the Court of Appeal immediately. And we then asked the Supreme Court to reverse that suspension. In other words, restore Judge Malouf's injunction with all of its force and effect. And to do that, we first had to ask the court for permission. And in a very narrow 3-2 decision, we were denied that permission. And that judgment could have made all the difference in history. But I think, too, that perhaps after a while, and I've got to give some of the government people credit, I think that after a while, some of the Indian and the Inuit people convinced the government that they were genuinely sincere in some of their requests, and especially in regard to hunting and fishing and trapping. And most of the thrust of discussions and negotiations was based on the traditional way of life. But I think from the government's point of view, there was a concern about what might happen in the future, and I think that to a certain extent they perhaps realized that maybe they hadn't viewed the whole Indian-Inuit question in the proper perspective. I'm not suggesting that that was that made the difference, but it was a contributing factor.
How much would have been, what would have been the cost of those hearings? Have you any idea?
The hearings which actually took place?
Well, the whole thing, the preparation, the transportation, presumably by air, of the contingent that came down representing the Inuit people and representing the Cree people. I was in 2 or 3 times, and I counted 15 or 20, and they were obviously from the area. They were obviously staying in hotels in Montreal. There's food for all these people. It would have cost,
Probably including legal fees and all the expenses for the last 2.5 years, I'd say somewhere around $400,000, $425,000, maybe a little more.
where would that come from?
Most of that came from the federal government, about 2/3 of it by way of grants and about 1/3 of it by way of loans. You see, normally, and so there's still a large part outstanding which is owed the federal government. Normally, in cases of significance involving Indian rights, the Crown, the federal government, has furnished the lawyers and has furnished the expertise. So that normally one could argue the Justice Department should have sent down its battery of lawyers and should have made its full Department of the Environment available and all kinds of other people's for the number of hours which were put in, and they didn't. And I would suspect that, quite frankly, they got their money's worth. I'm obviously involved in that, but I would suspect that they got their money's worth the same. They got the same effort, to say the least, they would have got had their own people done it. But it would have been their duty as the trustee of the Indian people to have done it themselves. They hadn't made this available to the Indian people. In fairness to Jean Chrétien, I mean, I don't pretend to say that he did everything right all of the time in this whole matter. I disagreed with him on a couple of questions. But fundamentally, I must give the man credit that throughout the bleak days of early 1973 and late 1972, he was one of the few federal ministers who was saying that the Indians do have rights, and those rights should be argued in court, they should be presented for a court decision, and we should do everything to help them. And that's what he basically did.
In your opinion, what is most beneficial, or what will be most beneficial to the Native peoples in the decision, or at least when everything is completed in the James Bay case?
Well, it's not known yet what's going to happen. The agreement in principle, which was signed on November 15th, provides that there are details remaining to be negotiated, and that if there is an agreement on those, then there is a full-fledged, final binding agreement on all parties. If there is not a full agreement on details, because most of it has been settled, but on the question of details, if there is not for some reason, then it's without prejudice to the rights of either party, and we're off again in the court battles. So with that caution, what is specifically provided for in the agreement in principle, and I think that a large part of the credit should go to the Cree negotiators and the Inuit negotiators who were present in all of this, the essential feature for them was to provide an option, and a true option, for their people. And basically, this agreement provides that those who want to continue the traditional way will be assured of being able to continue the traditional way. Those who want to go another route will also have all kinds of possibilities. The James Bay agreement in principle, though, I think a lot of people lose sight of the fact that it is also an agreement in respect to the form that the James Bay project will take and that future development will take in that area. And that was the essential and #1 goal, to do something about that. You know, they were true to their word. And there is no doubt in my own mind, I participated in a lot of this, that they could have had substantially more money had they wanted or accepted substantially less in terms of project modification and in terms of other benefits dealing with the environment and environmental measures to protect the hunting and fishing and trapping. So the hardest part was to ensure to the people that they'd have the traditional way of life to hunt and fish and trap. And I have to admit that after a while, the government people opened up on that when they saw how serious they were. They weren't talking about money every second day of the negotiations. In fact, they kept prodding, when are we going to talk about the money? When are we going to talk about the money? And the Indian people and the Inuit people were saying, we don't want to talk about the money. We'll talk about the money at the end if we get settled all these other things. So, you know, they put, to use our white man's expression, the Cree and the Inuit people put their money where their mouth was, because the settlement could have been far more favorable to them in monetary terms had they not concentrated so much on what they considered to be the essential aspects. And that, again, is due mainly to the Cree and Inuit negotiators who were there.
Who exactly was the other party?
Well, there was the Hydro-Quebec, there was the James Bay Energy Corporation, there was the James Bay Development Corporation.
On the Indian side.
On the Indian side, the Crees and the Inuit were...
What role did the Indians of Quebec Association?
Well, the Indians of Quebec Association at the beginning were the people who, I think, in all fairness, stimulated the Crees. I think Max Groslouis played a major role. Andrew DeLille played a role as well. They encouraged the Cree people to take the matter into their own hands and to say that they've got a case and they should fight for their case. And they encouraged them throughout the court proceedings. In the court proceedings themselves, 3 of them, the executive of the Indians of Quebec Association, were in the court case, but they didn't have any rights as such. They were there, in a sense, symbolically, and the case was dismissed against them, but that's not important. What happened is that they encouraged them to take the case, and they helped ease the financing load and use their contacts with Ottawa and encourage them throughout and helped arrange transportation and that. They also were in at the beginning of the negotiations, and then after a while the Cree people felt and the Inuit people felt that they could now take matters over in their own hands and that they were looking more towards a northern settlement. There was an attempt made to settle everything immediately, but after a while, because of the project, because of the urgency of the works which were going on, and the fact that it was being built day after day, it was felt that by the Crees and the Inuit that it would be preferable to go for a northern settlement, and that also they were able to take matters over entirely, and so they did. So that's what happened. So I think that it's a normal, natural development in the process of Indian organizations and Indian groups, and there was a time when the Crees badly needed the association's help. The association's help was given. There was also a time when it was preferable and better from many points of view that the Crees then took it over by themselves, and that's what they did. And so with the Inuit as well. Now, I'm very hopeful that that this settlement in principle, agreement in principle, is going to benefit the other Indians of Quebec. And to me, there is no question in my own mind that if they want to gather together and if they want to push and work, that they can do a lot for the other Indians of Quebec. The Court of Appeal judgment obviously doesn't help anybody, but we all knew that was coming. And I think that still doesn't detract from the fact that the settlement in principle is a great precedent in Quebec. And if the other Indians of Quebec utilize it, then I think that they could end up getting at least some of their goals or some of their targets. One has to be realistic in negotiations, though. If one wants the moon, one's not going to get the moon. If one wants to come down to Earth and start orbiting a little closer to Earth, then one can achieve a great deal.
Given that there's an agreement now, has any consideration been given to appealing the Court of Appeal's decision?
Yes, in the agreement in principle, there's a specific reservation that both parties can put the case before the Supreme Court. Pardon me, and wait to see. If there is no final agreement which is signed, then the parties could continue their court proceedings. And, you know, it's a gamble. It's a tremendous gamble, this whole thing, on both sides. Because it could end up, from the government's point of view, they could easily say, well, yeah, we're not giving up all that much. What happens? A year's not such a long time. We can't put anything in production until 1980. What if the Indians stop us before 1980 again? All it takes is one more court victory by the Indian people. And as tremendous as the odds may be against them, all it takes is one more court victory, and the project could have some difficulties. On the side of the Indians, of course, there's the mentality of the courts. It's pretty hard to say to judges, well, we have this sort of agreement, but on the other hand, if it doesn't work out, we want to come back to court. You know, there'll be a reluctance on the part of courts to be as open-minded. I shouldn't say be as open-minded, but to feel the same sense of urgency in this type of a situation as if there were no agreement.
Here's the Calder case that you referred to.
The judgment was in January of 1973.
What was there? What happened with the Nishka? What event was there that pushed their claims in particular, as opposed to some other tribe out there?
The Nishkas for many, many years, and it goes back into the 19th century actually, late 1800s, they had pressed for their claims based on Aboriginal title. And they were a very closely knit group, about 4 different bands, I think, the Ness Valley, and they had always from time to time made representations and asserted that they had these rights, and finally they even tried to make petitions. They went to Ottawa a number of times. I know they made petitions overseas, and finally they decided once and for all that they had it, that they were going to have it decided by the courts, and they financed their own court proceedings in the, I think through all levels, but at least in the Supreme Court of British Columbia and in the Court of Appeal. What's very fascinating too is that Tom Berger was their lawyer, and he is now Mr. Justice Thomas Berger, who has been assigned by the federal government to look into the Northwest Territories question.
Could you explain a little about the current project involved with land claims that a number of people, anthropologists, geographers, and so on, are involved in the Arctic, and exactly what relationship that might have to this case, or even cases to come in the future? I'm wondering if, you know, are all of these studies for land claims being done with a specific purpose, some sort of judgment in the future?
Well, I know of certain studies being carried out, for instance, in the Northwest Territories, and by particular Inuit groups. And I know other Indian organizations across Canada are carrying out some studies. They're towards a basis of reinforcing or establishing Aboriginal rights. And one of the elements of establishing Aboriginal rights is to show that you occupied large areas of land, actual land use. So it takes a certain amount of land use study, historic development. Geography is very important in that. Descendants, anthropology, ethnology is also a crucial factor in all of that. You have to be able to show the link between the people now who are claiming the rights and their ancestors who had these rights, who actually occupied the land. So their efforts are geared towards eventually submitting a claim. How that claim will be disposed of could depend upon many factors. It might go into direct negotiations with the federal government. It might go the route of some kind of a court battle, and followed by negotiations, or simply a court battle to stop a particular project. I don't know. Or it might simply take the route of making known to the public general positions for the time being, or presenting something to the Berger Commission, which then would make recommendations to Canada and to Parliament. This whole area of law has developed very quickly. I will say I had my doubts about anthropologists in general prior to the James Bay case, but those who worked with us did a fine job, a really excellent job, and certainly when they stick to their own expertise, they can be very helpful. I think probably the problems arise, just like lawyers, when they go all over the place, that they get into trouble. Yes?
What does the Navigable Waters Act have to do with James Bay?
That's an excellent question. You want me to tell you what John Marshall said? Nothing. What we said was that it had a lot to do with James Bay, that this was a definite area of federal jurisdiction, that certainly that to interfere in any way with the navigable waters was a breach of federal constitutional authority. The federal government hedged on that one considerably, and the point was not decided. We raised it. We raised it in both the Superior Court and in the Court of Appeal, and they decided on other grounds. The Court of Appeal didn't mention it at all. The Superior Court said because of the decision it wasn't necessary to decide these other things. I wouldn't count on that as a real factor. Legally, it should be a pretty strong argument, and I think it is a strong argument to raise. But they're having the same problem in northern Manitoba right now with the Churchill-Nelson diversion, which is going to apparently affect a number of reserves. And they don't, the federal government is very, very reluctant to move on that question for obvious reasons. What they would be saying logically is that they have a veto on an entire power project, because if you can't touch the rivers, if you can't put an obstacle in the rivers without the federal permission, then the federal government could logically say, well, we want to see all the designs of the dams and the spillways, and we want to see what your plans are for reservoir fillings. We also want to see what environmental precautions you've taken. It opens the door quite wide. And so the provinces have taken a consistently firm attitude against the Navigable Waters Protection Act being applied in a wide sense. And they use all kinds of arguments. Among others, they say that, oh, in any event, these aren't navigable waters because there are some rapids. From a legal point of view, some of the arguments are not bad. But on the whole, it's surprising to me. There are many areas of federal jurisdiction which haven't been precisely determined. What is the constitutional authority of the Government of Canada in respect to environmental matters? That hasn't been precisely determined as yet. Under peace, order, and good government, constitutionally, can't they raise some arguments? They probably can. They've chosen not to. The Fisheries Act. The Fisheries Act is clearly federal. It says no deleterious substance should be put in the water. Maybe there would be a few with some of the projects and also with some of the preparatory works, and they're not moving on that. Now, these are some of the reasons why it was argued earlier, and I think why the federal government was so interested in the settlement and in some of the environmental aspects of the settlement in principle, is that they recognized, I suppose, to at least a certain extent, that they did have some constitutional responsibilities that they weren't filling with the greatest of dispatch.
Tell us what the Cree and the Inuit started out by asking for the government, which led up finally to the settlement of November the 15th.
Sorry, I didn't catch your question.
Yeah. Can you tell us what the Cree and the Inuit started off by asking for in their negotiations, which led to the recent settlement?
No, I can't. I can tell you that the main items that they wanted to deal with were project changes, and they got part of what they asked for. A fair part, actually. The second big item was land. And the third big item was hunting and fishing. They got basically what they wanted on hunting and fishing and trapping. There's a whole new regime set up, which is in large measure the Philip Cree from Mistassini. That's one area where they were quite successful, and they'll be participating in game management. For practical purposes, they have the ownership of all the fur-bearing animals in the north, which is fairly considerable. In regard to land, they would have liked to have had more land for their exclusive use, but it's a point which perhaps is escaping a lot of people, is that 25,000 square miles for the Cree and 35,000 square miles for the Inuit are being set aside for their exclusive use, meaning there can be no development, nothing, no white activity in there other than pure administration or exploratory or scientific activity. So that land is theirs only, except that they are limited to the use of that land. They can only use it for hunting and fishing and trapping and related activities, such as tourism, some commercial fishing. But they can't open up mining developments or open up forestry developments, but that's not the traditional way anyway. So that is a very substantial concrete achievement. That land can be taken away for development if it is replaced. Or if the Indian or Inuit people want, there is compensation on an amount agreed upon. But the option is with the Indian people and the Inuit people. If that land cannot be replaced, it cannot be taken away. So there is a guarantee that there'll always be, notwithstanding expropriation and all other things, there's a guarantee that there will always be 25,000 square miles for them for their exclusive use, on top of their 2,000 square miles for reserves, over which they'll have even greater authority. And they'll have things like some regional governments, some local governments. That aspect of the settlement really wasn't caught in the reports that I saw. Yeah.
Where? If the government decides, let's say, to take away the 25,000 square miles, where would the Indians go?
Well, they would have to replace it up north in some way. We're talking about what's called Category 2 lands. We're not talking about Category 1 lands. Category 1 lands are subject to an even greater protection. These Category 1 lands, for all practical purposes, are called reserves. There is where they would be living. That is where their villages would be, not in this other area that I've been talking about. And in this area where they'd be living, they'd have even greater protection. The final points have to be worked out, but a great part of that will come under federal jurisdiction. Now, technically, federal government, like any reserve, can take away parts of the reserve, but has always been pretty reluctant to do so, and let's hope that continues. Even with Caughnawaga, where there was a substantial amount taken away for the seaway, the end result of the settlement was they got over 750 out of 1,200 acres taken away. 750 were given back. So even in situations like that, there's at least some hope. But you can't, as I was telling somebody in the break, you can't put an absolute protection. You can never prevent totally the exercise of parliamentary sovereignty, the sovereignty of governments, and of the elected representatives of the people in our system. You can try, we've tried to do it, there's a hope we can put some in a constitutional amendment, but even constitutional amendments can be changed by joint action of the federal and provincial governments. We have tried by the fact that there will be federal and provincial legislation approving of the agreement, as is. We've tried to make that some kind of a protection so that hopefully the federal and provincial will act as buffers against each other, and the Cree people, instead of being played off as the middlemen between the federal and provincial governments, maybe they'll join the three-ring circus and have something to say, as can the Inuits. But you can't provide a 100% absolute guarantee that nothing will happen in the future. We've tried, we've thought about it, and life is not like that.
Where do you think the Category 1 and Category 2 lands, where do you think where it would be that the Cree and the Eskimo would like it to be? Where would they choose?
Well, the criteria in the agreement in principle is that for Category 1 lands, it's air.
In terms of royalties, or?
Yes, there are no mineral rights as such, but the technique which has been adopted comes to the same thing. Insofar as reserve lands are concerned, no minerals, oils, metallic substances can be extracted from reserve lands without the consent of the Indian people, or the people as the case may be, and only upon such terms and conditions as may be agreed upon. So they can't get them out unless the Indians consent. So that's an inducement to consent. In regard to the other areas, there is a provision in the agreement in principle, which hasn't been reported very much, but it's that over the next 50 years, in respect to the development that takes place, and development is defined very widely, the Cree and the Inuit people will get 1/4 of what the province is entitled to get from such developments. However, the payments to the Cree and the Inuit people will only continue for a period of 20 years in regard to each development. So that if, say, by any chance a gold mine opens up somewhere, they get 1/4 of what the province gets from the gold mine for 20 years. Then if there's a huge ore body discovered somewhere else in the territory, then they get 1/4 of what the province gets, and that includes mining duties, incidentally, similar benefits. So that it's a gamble on the future, but it's what you call participation in the future development. This was thought about a long time in committee, and it was really felt that it's one thing to have the mineral rights, but somebody's going to have to develop anyway, and the risks in effect are minimized. The toughest point about that was trying to make sure that the province couldn't get around this by way of tax concessions or tax exemptions, and in effect nullify the benefits to the people. So hopefully we've tied them up on that. And in fairness to the province, they opened up a little on that. But that, that could be worth zero, and it could be worth a lot of money.
If there aren't any further questions, thank you very much for coming to share so much of your knowledge with us. I know that I'm sure everyone appreciates it very much. I certainly do. Thank you very much, Mr. O'Reilly.
don't know what's wrong with it though. Can you see it? Talking to everybody?
Good kid. Okay, pan down again for it.
It's very hard. The focus is bad.
Get ready to do a quick pan with the phone.
Yeah. Out of focus again. Hey, I haven't got very much luck.
Yeah, you're right. There's like a sort of focus. Okay. This way. Doing the can with it. Anything happening with Ken back there?
Talking to a lady. Excuses are quite. Right there at the door at the car.
Anything happening behind me? Okay, turn it. How are you? Tapes.
Has a, well, all of the cooperatives have a retail store, and in most cases the only other stores in the communities are the Hudson's Bay Company. In some of the communities the cooperative is the only store. We also have a production or a craft development section which provides the co-op members with some training. For instance, in the print, the Eskimo Prints. You'll excuse me if I say Eskimo. I'm an old-timer. If I'm speaking Eskimo, I say Inuit. If I'm speaking English, I say Eskimo. I hope it's just a habit that I've hung on to for the past 26 years. We do send in certain specialists to assist the native artists with technique, for instance, in the production of prints. This is not really an Eskimo art. The technique of printing is not Eskimo. The fact that that this is finally put on paper, it doesn't really deter from the fact that everything that that is contained in the picture is Eskimo, and it contains Eskimo thinking. We also have an auditing service which provides each cooperative with an audit at least once a year, and with help in financial problems throughout the year. We have a training program which provides the native peoples with the skills whereby they can run their own businesses. In the north itself, there are no white employees whatsoever. The manager, the store manager, the production manager, the purchasing manager, the tourist manager, all of these people are native peoples. And all have been trained by us to do their job. How well they do it depends on the individual. Sometimes there's a lot to be desired, sometimes they go way beyond what we expect them to go. The Federation was set up to correct a situation which existed then in northern Quebec, and I think it exists now in the Northwest Territories. Definitely it does exist, where you have each community or each Eskimo group working on its own, trying to get ahead without any help from anybody else, especially from their own people, without any real coordination of their effort or any interchange of ideas or interchange of produce. We're involved in the economic development. This includes things such as meat or fish. A community that has lots of meat, we are collecting this meat, buying it through the cooperative organization, shipping it to communities that are short on meat, where it's again sold through the cooperative organization. When we're working in things which are Eskimo, such as meat or soapstone or fish or skins, anything that is typically Eskimo, we find that most of the managers they don't like to take much of a markup on this type of merchandise. When it comes to southern merchandise, they're very, very aggressive merchandisers. They'll go after every 0.5%. But when it comes to their own thing, well, you know, as long as the markup will cover handling, that's all that they care. Also, the Federation was set up to try to get the control of economic development into the hands of the people themselves. Practically everywhere in the Northwest Territories, whenever you talk about economic development, you'll say, oh, the economic development over there is Joe Blow, or it's Jane Jones or somebody. There's always a white person involved in this so-called economic development. There's always government money involved. What we tried to do was to get away from this, so that if there is economic development, the only money that's involved is Eskimo money. The only people that are involved are Eskimo people, or people who are hired specifically by the Eskimo people to do it. And in the situation that we have developed, and in the way it was set up, we made sure that it was the native people who had the control. If they didn't like, even if they didn't like the look of a guy, they could fire him right away. If they didn't like the way something was done, well, the next time there was a meeting, he was out. This includes people that were on the southern staff, as well as people who have visited through the north. You know, you've got to be a fairly nice guy. I'm not saying this because I've managed to survive for a few years, but you've got to be able to get along, and they have to really believe that you're doing what they want you to do if you're going to survive in the organization. We've lost a lot of very good people just because the native people felt, well, they just didn't click. We've lost some people with some very high degrees and people who are very highly thought of in the southern world just because Eskimos didn't like the way they operated. The situation as it was in 1967, there were cooperatives at Puvangnituk, at George River, Chimo, Payne Bay, and there were even 2 cooperatives at Great Whale River. The Puvangnituk cooperative, this was basically controlled by the Quebec government. It was a combination of the Quebec government, the Caisse Populaire des Jardins, and Father Steinman. It was considered at that time to be the French co-op because the French people were involved, the Quebec government and Caisse Populaire people. It was sort of Quebec oriented. The other co-ops, the co-op in George River, Fort Chimo, and Payne Bay, they were more or less supervised and controlled by a federal development officer who was located in Fort Chimo. The Great Whale, there were 2 there. One was the federal co-op and the other was the Quebec co-op. There were no Eskimo or Indian ones, they were just federal and Quebec. One contained mostly the Eskimo members, and they were more or less controlled by a development officer on the federal government employee. The other one had a considerable amount of provincial government involvement, and also there was a priest involved in this one too. The 2 cooperatives, one was basically Indian, the other was basically Eskimo, and they more or less competed, each one trying to pay more than the other one, and it didn't work too well. As a matter of fact, the Indian cooperative was pretty well bankrupt by the time the federation was set up. The federation, it started, as I say, to try to correct some of these problems. The idea originated at a meeting of Eskimo and Indian people in Frobisher Bay. I think it occurred in 1964 or 65. At that time, they were discussing the direction that cooperatives should take in the north, and somebody came up with the idea that there should be a number of federations which would provide services to the cooperatives. The Quebec cooperatives, because they are incorporated under provincial law, and since the province of Quebec had legislation which enabled the people to set up a federation, it was the first to get moving. And I was asked in 1967 to set it up, and that's what I did. It was set up by Well, I was asked by the Puvungnituk Eskimos to work with them, and they suggested that I go to all the various communities in northern Quebec and ask the people what they thought, and if they agreed, then the federation would be set up. For the Eskimo people to agree to have a federation of their own, it was a big decision for them to make, because up till that time, most of them were getting government assistance in one form or another. The white people were all paid by government. In many cases, buildings were given by government. Loans were made by government. And if anything went wrong, government usually took care of it. For instance, George River, they had a small store. They ordered materials for their store. It was sent in on a government ship. I don't know, the ship either sank or a barge sank and they lost all their stuff, so the government gave them another loan and let them buy it all over again. Being government, of course, they couldn't have insurance on it, so the co-op is still working to pay that off. But when they decided to try it on their own, they were warned in the beginning that most likely, since governments don't like to lend money or give money unless they have complete control over it, that if they set up a federation on their own, things were going to be awfully tough. The only thing that they could get in exchange for all this money and all this assistance was a feeling of, well, we're doing it on our own. Well, this is not very much when you look at all the hundreds of thousands of dollars that was being poured in a year by. But the people did decide, well, they'd try it. They felt that they had no control at the time, and even if they failed, well, so what? You know, we're not losing anything that's ours anyhow, because although they're supposed to be cooperatives, they're not. We don't have the final say. So let's try it. The actual mechanics of setting it up, we brought 2 people from each community. These people were elected. They came down, they sat for 6 weeks, and they worked every day to figure out just exactly which direction they wanted to go, what bylaws they would set up. I think the fact that we spent so long in the beginning in getting the people to really understand, to let everybody really talk themselves out and say exactly what they wanted and how they wanted things done. I think that this is the reason why we have succeeded to some extent up to now. The basic objectives that they had then, when we bring them down to economic points, they wanted to have a standard type of pricing, a standard quality on all their products, whether this be fur, prints, carving, anything that they make. They wanted to, they didn't want to compete with each other as far as like one cooperative trying to undersell another cooperative on fur, or trying to pay more to the producers than another cooperative. So this meant that there had to be a lot of discussion and a lot of, in a way, economic control by the board of directors of each cooperative. Also, they wanted to have standard prices for everything sold in their stores. In other words, if you go to Puvungnituk, you can buy a bag of sugar for the same price as you can buy it in Ibuivik, even though Ibuivik is a much smaller cooperative. The ratio of their overhead is much higher when compared to, say, the volume which is done at Puvangnituk. But no matter where they went, they wanted to be able to buy things for the same price. A bag of flour has to cost exactly the same in Great Whale as it does in Chimo, even though there's an extra $1,000, an extra 1,000 miles of transportation to be put on it. This meant that the closer cooperatives were willing to share in the expense in provisioning the further ones. Also, they wanted to have the same right to development, even though it's a smaller cooperative. These people felt that they had just as much right to have a tourist camp as a larger cooperative, even though they didn't have the financing to do so. This meant that each cooperative would have to help in financing all the other, or the smaller cooperatives. The richer ones would have to help the poor. And in many cases, they knew that this was going to hold them back as far as their own development was concerned. They wanted to have an organized approach to resource harvesting in areas where there were a lot of seals. Even though there was a good market for seal meat and seal skins, they didn't want the people to overfish or overhunt in any area, so that in the long run the people would be able to benefit for many years rather than just a few years. They wanted to combine their produce, like their fur, so that they could get a better price. They wanted to combine their imports so that they could get a better price. All of this was discussed in very fine detail at the beginning, and we're still following exactly the same rules today as were laid down in 1967. If I'm going too fast and somebody wants to stop me on anything, just do so, okay? Another point that they wanted was that every community have the opportunity to have a cooperative if they so desired. Because of this, this was one of the things that we worked on, was to go into each community with Eskimo or Indian people from other communities where they had a cooperative, and try to discuss with the people, and if they wanted to set up a cooperative, to make it possible for them to do so. In this way, the two cooperatives at Great Whale were amalgamated into one cooperative. This was quite a ticklish problem, because the Eskimo and the Indian people had always been a bit mistrustful of each other. Each one thought he was better than the other one. We did accomplish the amalgamation of the two cooperatives, but there are still problems in Great Whale in trying to have the Eskimo and the Indian people work together. Many of the problems come out of a lack of understanding. For instance, the cooperative will finance a caribou hunt by using aircraft. The Eskimo people go out first. If they get a lot of caribou, well, the directors will say, well, we should send the Eskimos out again because they got a lot of caribou, and maybe the Indians won't get as much caribou as the Eskimos did. And the Indians, of course, would fight for their rights. And then if they do go out and get less caribou, well, then next year, you know, everything is all balled up, because they'll say, well, last year we tried it, the Indians didn't get anything. But the same thing could happen to the Eskimos. too. But this is the type of problem. It's a problem of pride of race. Also, you have a situation where in the South, the generally, I think that the white public is more sympathetic toward the Eskimo. For instance, anything that is made by an Eskimo, whether it's an Eskimo doll or an Eskimo piece of soapstone, oh, everybody goes crazy about it. They say, oh, this is fantastic art and this is great, and you know, we can ask $500 for a doll that's made by an Eskimo. You know, nobody thinks anything of paying it. But you try that with anything made of Indian, boy, that's a completely different, a very different situation. We have Indian carvers who have been carving soapstone. The Eskimos say, well, hell, if he wants to carve soapstone, he can carve it as well as I can, so let him carve it. It's our co-op. But in the marketplace down here, you know, we have a little tag. It says Eskimo art. We can't put Indian art in with Eskimo art. You'll have a buyer coming in and they, oh, these beautiful little carvings over here, you know, gee, the price is reasonable, everything. Soon as you mention they're Indian, no, we're not interested. It's the same carving, but, you know, there is definitely a prejudice in the South in favor of Eskimo. Notice I didn't say that there was prejudice against Indian. Maybe I meant it. We're finding this in many in many of our business transactions. We go to a supplier, we say, well, the Eskimos are doing this, the Eskimos are doing this in the north, we have these cooperatives. Fine, you can get a line of credit, no trouble. You mention Indian in it, it's out, you know. Then you have to go to Dun & Bradstreet, check everything, and make sure that your credit rating is fine. But this is one of the problems that we find. We are an Eskimo and Indian organization, and you know, we'd go a lot faster if we were just Eskimo. And I don't think that it's because there's the Indian people are in any way different. It's just because of the attitude of the white people in the South. We have, this is one of the small problems that we have. Then in Sagluk we set up a cooperative in 1967. In Ivuyavik we set up a cooperative in 67, and in Inujuak we set up a cooperative in 67. And in 69, an Indian community, their cooperative was set up and they joined us in 69. And in Wakem Bay in 1970, which brings the total number of cooperatives up to 10 right now. There are two other small communities in northern Quebec, Quaqtuck and Leaf Bay. They're very small communities. They are communities which are set up by governments. They're controlled by governments, and these two communities do not at the present time have cooperatives. The problems that we have, there are problems from outside, problems from inside. The outside problems are mainly a mistrust on the part of governments mainly, or a belief that the native peoples cannot do things on their own. The government would like to have much more control over what the Federation is doing. In many times we've gone to government and asked for loans. Loans have been offered, but only on the condition that governments have a say in how the money is used once the money is turned over to the Federation. in every case, we have, or the directors have refused to accept loans under these conditions. Last year was the last time government came to us with such an offer. They offered to lend us $2 million. The Eskimos refused their terms, so we didn't get the money. We'd like to have the money. It would really speed things up. Also, governments feel that our federation should be set up more like a southern business, and that we should follow southern business standards and procedures. The Eskimos and the Indians say, well, we want it set up so that we can understand it, and so that the priorities that we set are the ones that you follow, not the priorities that government set or anybody else set. For instance, a cooperative which is very quickly building up capital and share capital and building up profits. If this cooperative wants to build a restaurant, and there's another cooperative which, because it's in a smaller community, or the economy is not yet developed enough, if they say, well, we need a new store, well, the directors will sit down, they'll say, well, I think that they need a new store more than the other cooperative needs a new restaurant. So even though they can't afford it, they get the new store. The other cooperatives will pitch in their money to carry them until they can carry themselves with this new store. Well, the banks and the business people in the South say this is just lousy business. If the people can't afford it, they shouldn't have it. Whereas this cooperative is being held back because of the backwardness of another cooperative. But this is the way the Eskimos want it. This is the way they get it. You know, who are we to say how they should run their business? There is there's also a competition in the North, a competition from government. Well, when you look at the economic operations in the North, there's the Hudson's Bay Company and there's the co-op. We never think of the Hudson's Bay Company as being a competitor. Up until now, the Hudson's Bay Company has always been something that the Eskimo businessman wants to try to beat, but not to beat as far as money is concerned, but to try to become as good a businessman as the Hudson's Bay man. One of the best aids that the Eskimo has had has been the fact that the Hudson's Bay Company is there, because being an established company, being a well-financed company, and their managers are quite well trained. They've got very good buying power. They've got it all, and this is what the Eskimo has to try to come up to, and if possible, try to surpass. Nobody in the co-op movement wants the Hudson's Bay Company to leave. You know, we want them to stay. We want them to progress too, because as long as there's somebody from outside that the Eskimo can sort of compare himself with, well, then he knows he's doing okay. They know that if the Hudson's Bay Company pulled out of the North, well then, you know, who do they show off to? You know, this is basically it. If the co-op can get more than 50% of the business, it means that he's doing a good job. And they really feel proud of the fact that, you know, we'll get a call from one of the managers in, say, Sugluk, and he'll say, oh, best day we had so far this year, yesterday. We had a fantastically good day. We did $15,000 sales. Hudson Bay Company only did $300 sales. You know, that's great, you know. The fact that they can say that for one day, anyhow, they beat the Bay at it, well, that's good. But when we talk about competition in the North, we think of government. because, for instance, we're in the tourist business. The government is in the tourist business. The Quebec government is trying their damnedest to get involved. The federal government have been involved for a long time. They will put up a tourist camp. They can spend all kinds of money at it. They sort of nominally appoint some Eskimo as being the owner of it. He signs a few papers, and then the government runs it with all their own staff. They have charter flights going in. They build all kinds of equipment, and then they bring tourists in. They've got quite a big access to the tourist market in the south. The Eskimo has to compete with that. He has to go in with a couple of tents and start building up from scratch, find his own tourists, first find the place where the fish are, which he has the advantage there, but then to get a lease for it, if the government wants a lease on it, the Eskimo is not going to get it. This is the type of competition that's pretty difficult. Also in the two communities I mentioned earlier where the government is operating the community, they have their own stores. Well, they can undersell the bay, they can undersell
One in Category 2 lands, where do you think where it would be that the
Well, the criterion in the agreement in that for Category 1 lands, it's areas the proximity of existing villages. Basically, for Category 2 lands, it has to be productive habitat areas, meaning productive from the point of view of beaver, wildlife, and all the rest. In general, there's one point. It's that point that we come back to. We were talking about it before. It's that those who want to continue the traditional way will be able to with modern methods and techniques, and that's what was worrying most of the people up north. And very, very seriously worrying most of the people. But yet there are enough other things in there that if they want jobs, they have jobs. If they want to have priority of contracts, they have priority of certain contracts. If they want to participate in the development, they can participate in the development. But most of the time,
given